The next case to come before the court this morning is State of Ohio versus Anfenee Crandall. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, let me know if you'd like to reserve any time, as I'm keeping the clock this morning. Please don't use the names of any victims or minors, as we are streaming this live, as well as it will be posted on the court's YouTube channel. We have read the briefs. We are ready to proceed when you are.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state of Ohio, which in this case is actually the appellant, which is a little unusual, but I would like to reserve 3 minutes of my time for rebuttal.
Certainly.
And, this case involves the granting of, or the partial granting of, a suppression motion by Mr. Crandall. And the state's position is that the trial court, when it did that, erred in 3 ways. First, the state's position is that there is competent, credible evidence in the record to contradict the trial court's finding that there was not a nexus between Mr. Crandall and the vehicle from which the trial court suppressed the evidence that was found in that vehicle, which was a firearm. The state's position is that there was indeed competent, credible evidence that there was a connection between that vehicle and Mr. Crandall, and that therefore the trial court erred in granting the suppression motion, because since there was a connection between Mr. Crandall and that vehicle, to show that he was using the vehicle in question, that the exception to the warrant requirement that's contained in 2967-131, which is for shorthand is the parolee exception, applied to permit the adult parole authority officer who participated in this search to search the vehicle without a warrant, based upon his reasonable grounds to believe that Mr. Crandall was in fact breaking the law and violating the terms of his post-release control. And so in that respect, that erroneous factual finding is the linchpin for an error, because the trial court did not move on to determine then whether the parolee exception applied. But in addition to that, however, by finding that there wasn't this connection between the vehicle and Mr. Crandall, the trial court essentially, but did not analyze whether it was so finding that Mr. Crandall didn't have standing in this case. And of course, standing is an essential element in any suppression motion, and it is always a defendant's burden to show that they have standing. Now, standing is very consistently defined in the case law as a legitimate privacy interest in the place or the thing to be searched, and in this case, vehicle. And there is no other definition for that. And the mere fact that an officer searches a vehicle does not confer standing upon the defendant. So this, by not analyzing whether Mr. Crandall actually had standing, the trial court erred as a matter of law rather than as a matter of fact. And in this case, Mr. Crandall did everything in his power during the suppression hearing to separate himself from that vehicle, which actually negated what he was supposed to actually show, which was that he had a legitimate privacy interest in this vehicle, such that he had standing to challenge the search. And finally, even if Mr. Crandall had standing, the trial court did not analyze whether this was a search that fell into the inventory search exception to the warrant requirement, which was something that was being argued consistently by the state and also in the testimony of the officers. And that, again, was not analyzed by the trial court. It should have, could have, but wasn't, if Mr. Crandall had standing. So in that respect, the trial court erred in three ways. No matter how it's analyzed, however, if Mr. Crandall had a connection to the car sufficient that it fell under 2967-131, the parolee exception, the evidence should not have been suppressed. If there was no connection between him and the car such that he had no legitimate privacy interest in the vehicle, then he had no standing to challenge the search or the evidence of the gun. And so that none of that evidence ought to have been suppressed. So that's basically the state's position. We do have testimony in the record to get into the first prong of this, considering the facts of the case. We do have evidence that does connect him to the car. Detective Meach saw an AMHA surveillance video showing the defendant leaving the car and going into his apartment shortly before the search occurred.
But that video was not introduced into evidence, if I recall, correct? So is that proper? Was it proper for the court to consider that in determining that nexus, since it wasn't introduced into evidence?
You're right, it was not introduced into evidence, but there is additional evidence. For instance, the Officer Leggett from the APA testified that Mr. Crandall's parole officer had information about the car that Mr. Crandall drove and then had permission to drive, and that was his grandmother's car, and that was the car that was searched in this case. In addition, that vehicle was parked directly outside Mr. Crandall's residence, the one that he had used when he signed up with the parole authority for the post-release control. So there is evidence in the record, aside from the video and aside from Detective Meach's testimony concerning the video, to link this vehicle to Mr. Crandall. But then, even if there really isn't any nexus between Mr. Crandall and this vehicle, that disproves, the lack of a nexus disproves standing, because if he's not the person who's driving this vehicle, if this is not the one that he has permission to use, then by saying this wasn't the one I was driving, he's saying I didn't have a legitimate privacy interest in this vehicle, and that negates his standing to challenge the search. So even though I know that he says that this is a catch-22, that is how the law stands, and it was his burden to show standing, and he did everything in his power to negate that. So that then transitions into his burden for standing, which again the trial court never analyzed. So without that analysis of standing, and the state did raise it during the suppression hearing, so that argument was preserved by the state. Then without that standing, this suppression motion as a matter of law should not have been granted. And that's a point for which this court has de novo review.
So counsel, does Mr. Crandall need to speak to the issue of standing and not remain silent regarding whether or not that's his vehicle? Does he need to affirmatively testify in suppression?
That would be a matter, I think, of strategy, but I'm reciting what the law requires. It is his burden to show standing. How he chooses to show that and how he chooses to demonstrate that is not necessarily up to the state. And while I understand the contention that this is a catch-22, that this might require somebody to arguably put themselves in a position where they might be weighing their rights against self-incrimination. there are other ways to show that. I mean, Mr. Crandall could have put his grandmother on the stand and said, yes, this is the vehicle that I allowed him to use. So it's not necessarily incumbent upon the defendant to always testify to claim a legitimate privacy interest. There could have been other ways. Again, grandmother could have testified. Girlfriend whose apartment this was, who had the lease on the apartment, could also have testified, yes, this is the vehicle that Mr. Crandall uses on a regular basis. This is the only one he drives. Grandmother could have testified, yes, I gave him, it's registered in my name. I gave him permission to use this. This is the one that he drives. That could have established a legitimate privacy interest in this vehicle sufficient to have shown standing. But that didn't occur. Rather, what happened was a disclaiming of this vehicle. So once that occurs, that's when the state, argued, well, wait a minute, if he doesn't have a legitimate privacy interest in this vehicle, if there's no connection between him and this vehicle, then there's no standing to challenge the search. So I hope that, Your Honor, that answers your question.
Yes, thank you.
So again, if Mr. Crandall had shown standing, then also the state's contention is that the court did not analyze whether the inventory search exception applied. And actually that even though we've made arguments as to whether that would apply, that may not be something that this court would consider on first instance. It would have to be something that the trial court would have to analyze, because it did not, in the journal entry in this case. So unless there are any further questions from the court, I think I'm probably eating into my rebuttal time. And so I reserve the rest of my time for rebuttal.
Thank you, counsel. You'll have approximately 3.5 minutes for rebuttal. Mr. O'Brien?
Your Honors, good morning. Thank you for the opportunity to address the court. With respect to the arguments of the state, I'll address them in the same order that they brought them up. With respect to them indicating that there was evidence that Mr. Crandall was driving the car, Your Honor, there was none of that presented in terms of the video that supposedly these officers are referring to. They didn't see Mr. Crandall drive the car. They didn't see him get in or get out of the car. They are relying on a viewing later on, a couple days later, that an AMHA employee provided a video of Mr. Crandall purportedly driving that vehicle into the parking lots.
Mr.
That
O'Brien,
AMHA, yes, Your Honor.
question about that. The officer, I guess a detective, testified that he viewed that video. For purposes of a suppression hearing, and only suppression hearing, wasn't that evidence?
Judge, with respect to him referring to that video, Your Honor, I would cite the court to Evidence Rule 901, which requires some sort of authentication or identification of that video.
But do those evidence rules apply in a suppression hearing?
Judge, I know things at a suppression hearing are not quite as rigid as before a jury, I would agree, but I would still argue that evidence rules apply across the board, even in a suppression hearing, with the exception of maybe the hearsay rules. I understand that in suppression hearings that the hearsay rules are somewhat relaxed. But Your Honor, there's no authentic, that if they wanted to talk about that AMHA video, number one, they should have provided the video, and number two, they should have provided the AMHA employee to authenticate that video. So what I'm saying, Your Honor, that there really is no admissible evidence to tie Mr. Crandall in that respect. Secondly, Your Honor, whether or not there is standing or not, I realize that the state of Ohio and trial prosecutor argued argued very strenuously with respect to the standing issue in front of Judge Bro. It's my argument, Your Honor, that I understand the idea of standing in order to assert the right of privacy and against any illegal search and seizure. However, Your Honor, that I don't believe that this was really an inventory search. I think what they did was the cops were arguing that, hey, we've got a parole officer with us and the rules go out the door as far as the police go because the parole people have fewer rules that they have to abide by. And that's true in court. You know, we often have to tell our clients, your trial judge has no control over the parole department. They operate on their own. Same thing here, Judge. My argument is that for them to argue that we had a parole officer, we didn't have to worry about search and seizure, that puts my client in an almost untenable rock and a hard place position. He can't assert one thing if he tries to assert another. So what I'm saying is that these officers, whether it's parole or detectives, were pursuing Mr. Crandall and wanted to detain him as part of the investigation. And then that, I would argue, covers Mr. Crandall with a form of standing because they went right out to his vehicle claiming that he had been in the vehicle, although they didn't really know that at that point in time. His detention, Your Honor, is that it gives him standing. Last, Your Honor, whether or not the vehicle was lawfully impounded, Your Honor, this vehicle did not belong to Mr. Crandall. It belonged to his mother, grandmother, Miss Robinson. And the vehicle was towed as an automatic reaction to any type of vehicle. The police automatically tow the vehicle because then, to them, it becomes an inventory search without any real justification. No crime had been committed that they saw as part of that vehicle. They just said, it's got to be some way connected. We'll figure it out later. And so let's make this a tow. We'll tow it, we'll inventory search it, and we'll find whatever we find, and we'll charge him with it. So what my argument, Your Honor, is, and I'm going to conclude, is that there was no reason for the police to tow the vehicle. There was no reason for the vehicle to be searched. And any contraband or purported.
Thank you, Counsel. Counsel for the state, you have 3 minutes and 40 seconds remaining for rebuttal.
Thank you, Your Honor. Just a few points. Counsel correctly notes that the evidence rules are not as strictly applicable to suppression hearings as they are at trial. And I would remind the court that this was not a trial. And so the suppression, the evidence rules do not apply with the same stringency that they do to a trial. Neither do the discovery rules. So the fact that the state did not turn over this video to Mr. O'Brien or to the defense prior to the suppression hearing is of no moment. As far as the parolee exception, there's no evidence in this case that this search was a pretext or were done in a pretextual manner. The officers were not searching for a gun. How this happened was that they were already going to arrest Mr. Crandall for suspicion of drug offenses. They went to his apartment. They effected the arrest. The parole officer was part of that. The mere fact that a parole officer or that the police are along with a parole officer in conducting a search of this nature under State versus Cowens does not make it fall outside the exception. As far as standing is concerned, just a couple of points. The definition of standing, again, is very well defined. It is a legitimate privacy interest in the thing to be searched or the place to be searched. The mere fact that there's a search does not establish standing. The fact that there's a detention does not confer standing on the defendant either. And as far as the impound of the vehicle, I would remind the court of what the testimony was, and that was that this car was not searched on the authority of the parole officer involved and was not searched, it was not put into impound on the authority of the other task force individuals who were part of this. It was put into an impound on the authority of AMHA policy, which is that when a person is given a notice that they are no longer welcome on the property, which Mr. Crandall was as a result of his arrest, then the vehicle cannot stay on AMHA property. And so because Mr. Crandall was not welcome to come back onto the property to take the vehicle off the property, AMHA policy requires that it be towed. That's why it was towed, you know, under the authority of the Akron police officers who were acting as AMHA officers that night. So it was their decision to tow the vehicle pursuant to set AMHA policy. So that's, I would remind the court of that. But essentially, in conclusion, you know, Mr. Crandall did not prove that he had standing in this case. Instead, he tried to separate himself from this vehicle, and thus the trial court erred in suppressing this evidence. And even if the trial court was right that there isn't a connection between him and the vehicle, he didn't have standing. So no matter how it's sliced, this suppression motion was erroneously granted either on the facts or on the law or on the lack of analysis. So in sum, unless the court has any further questions, the state would rely on its briefs and ask this court to reverse and remand it to the trial court. Thank you.
Just one quick question on that inventory search. If the record shows the vehicle was owned by grandma and the grandmother did not get that notice that you were talking about, would that negate the inventory exception? In other words, if it's her car and she didn't receive the notice, they wouldn't have the authority under the AMHA policies to tow it, correct?
I'm not sure that that is correct, Your Honor. But that probably should have been something for the trial court to have analyzed, but it did not. And that's part of the reason why the state is arguing that this needs to go back to the trial court, either for further analysis or just a reversal.
All right, thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next oral argument is scheduled for Thursday, September 9th. We are adjourned. Have a wonderful day, counsel.
Thank you.